After understanding the purchaser's rescission rights and the critical role of full and transparent disclosure, it is important to explore the continuing obligations placed upon timeshare developers even after their public report has been issued and sales have begun. Arizona law does not allow a developer to set and forget their timeshare plan once approved by the Arizona Department of Real Estate, ADRE. Instead, developers are required to maintain compliance by reporting any material changes to the timeshare plan, marketing program, or related operational conditions. This ensures that consumers, brokers, and the ADRE remain informed of significant developments that could affect the integrity, value, or fairness of the offering. The legal foundation for this obligation is found in ARS Section 32-2197.04a, which mandates that a developer must promptly notify the ADRA in writing of any material change in the information contained in its previously issued public report. The purpose of this provision is to ensure that the public report always reflects the true current state of the project. A material change is any fact, event, or alteration that would be significant enough to influence a purchaser's decision to buy, or that would substantially modify the terms or representations of the original offering. For example, if a developer initially represented that each timeshare purchaser would have access to a private clubhouse and indoor pool, but later decides not to construct these amenities due to financial constraints, this constitutes a material change that must be reported immediately. Similarly, if the developer's management company changes, if there are modifications to ownership structures, or if liens or encumbrances are recorded against the property, these all represent material changes requiring disclosure. Under ARS Section 32-2197.08b and ARS Section 32-2197.04, the developer must submit an amended application for a public report of discovering or implementing any material change. This amendment must describe the specific change and include any supporting documentation necessary for ADRE to evaluate the impact on existing or potential purchasers. Until the department has reviewed and approved the amendment, the developer may not sell or advertise any additional timeshare interests affected by the change. The ADRE's role in this process is not merely administrative, but protective. When a developer files an amendment, the department assesses whether the change materially alters the purchaser's rights or the risk profile of the project. If the change is deemed significant, ADRE may require the developer to provide written notice of the change to all existing purchasers and prospective buyers, ensuring they are not misled by outdated marketing materials. To illustrate, consider a developer who modifies a timeshare plan to reduce the number of available units from 200 to 150, reallocating the remaining inventory to a different ownership structure. Because this affects the purchaser to accommodation ratio, ADRE would likely require an amended public report and notice to all purchasers. Similarly, if a developer introduces a new exchange program or alters how reservation rights are assigned, such modifications must be reported, as they change the operational character of the timeshare plan. Failure to disclose material changes is treated as a serious violation under ARS Section 32-2197.19 and ARS Section 32-2153, which prohibit making false statements or omissions in any public report or marketing material. Developers who knowingly withhold information may face administrative penalties, license suspension, or civil liability to affected purchasers. In Arizona versus Diamond Resorts Corporation, the Arizona Attorney General's Office, often in connection with ADRE regulation and consumer protection law enforcement, reached a settlement involving deceptive sales practices in the timeshare context. That matter involved allegations that sales presentations contained misrepresentations about maintenance fee increases, resale or buyback programs, rental income, and discounted travel offers, and resulted in an $800,000 settlement with consumer restitution and implementation of disclosure changes. In that settlement, qualifying Arizona purchasers were offered a relinquishment remedy program that allowed some consumers to return timeshare interests with no further financial obligation if complaints were filed by a certain deadline. Furthermore, marketing changes, such as offering new incentives, contests, or referral programs, must also be reported to the ADRE before implementation. The department ensures that promotional materials comply with ARS Section 32-2197.17 and ARS Section 32-2197.19, which prohibits false, misleading, or exaggerated advertising in timeshare marketing. For instance, if a developer begins advertising lifetime access to vacation weeks when in fact ownership rights expire after 20 years, the ADRE would consider this a material misrepresentation requiring immediate correction and disclosure. The underlying policy principle here is consumer protection. Purchasers rely on the accuracy and completeness of the public report when making a substantial financial commitment. Arizona law ensures that the document remains dynamic, updated whenever the realities of the project evolve, by requiring transparency and consistency. ADRI safeguards both current and future purchasers from being misled by outdated information. Review summary. Developers of timeshare properties in Arizona must continuously disclose any material change in the project, its ownership, or its marketing practices to the Arizona Department of Real Estate under ARS Section 32-2197.17 and ARS Section 32-2197.19. Material changes include alterations in amenities, management, ownership structures, encumbrances, or marketing representations. Immediately of identifying such changes, the developer must file an amended public report application. The ADRE reviews these amendments to ensure ongoing compliance and may require direct notification to purchasers. Failure to comply can lead to administrative sanctions, civil penalties, and possible license suspension. Discussion prompts. Why does Arizona law require developers to amend their public report when material changes occur? Answer: to maintain transparency and ensure that purchasers make informed decisions based on accurate, current information. What are examples of material changes that must be disclosed to ADRI? Answer: alterations to promised amenities, changes in ownership or management, new liens, or modifications to marketing or exchange programs. What can happen if a developer fails to disclose material changes? Answer: the developer may face fines, license suspension, or civil action for misrepresentation. The court may award reasonable attorney fees to the defendant in violation of ARS Section 32-2197.19. Closing remarks. The obligation to report material changes is one of the most critical ongoing responsibilities of a timeshare developer. It ensures that both ADRA and consumers have access to accurate, up-to-date information about the project. Compliance not only fulfills legal obligations, but builds public confidence in the integrity of Arizona's real estate market. Developers who embrace transparency demonstrate a commitment to ethical business practices and protect the long-term reputation of their communities and the industry as a whole.